Items for delivery of judgment. Item 1, WPC 4387 of 2023.
Petition dismiss.
Item 2, PRP 96 of 2025.
Dismiss. However, 2 months time is granted to the petitioner to vacate the suit premises. Much obliged.
Item 3, I Civil 306 of 2025.
Dismiss.
Number 26.
Yes.
Petitioner herein is aggrieved by the order dated 7/1/2026, my lord, whereby my application for framing a preliminary issue with regard to that the suit is barred by res judicata has been dismissed. Now, my lord will kindly first come to page 17, my lord, the earlier suit that was filed by the respondents, my lord, as a plaintiff against the same
Page number?
page 17, 17. The plaint of the earlier suit starts from page 14, 14. This is a suit of 2012.
Where is the schedule of the land?
Yes, my lord. The page 23 is the schedule, my lord.
This plaint is of earlier suit.
Earlier suit.
Okay. And
Schedule call is the schedule call was the subject matter of the suit, my lord.
okay.
It is 2 katha covered by DUG number 116, annual patta number 37, 38, 34. And the boundaries are, my lord, north, homestead of Raghunath Dole, south, hardware shop in RCC rooms of plaintiff, east, reserve land of Pohumara Pokia PWD road, and
Okay.
west, land of.
Where is
Now, my
the
lord, will kindly come to the prayer portion, my lord.
Where is the schedule of the present suit?
In the present suit, my lord.
Yes.
Yeah. Here, page 97. Same schedule of land, my lord, that was earlier as schedule co in the earlier suit. Here, my lord, they have made the schedule co and the prayer are also same, my lord.
The patta number is different.
It's a new
Earlier one, the present one is 33.
33.
Earlier one is 37.
34, my lord, new. That new patta is 33. Well, there's no dispute even in the present suit plaint also, my lord. They have categorically shown the cause of action is dismissal of the title appeal. If your lordship will kindly come to page 22, my lord, the prayer in the earlier suit. Page 22, my lord, finds. First, decree of declaration of that the order dated miss case number so and so under section 144 of CRPC, the land described in schedule co, that is 1 biga 2 katha 14 lessas, subject to the title of the plaintiff pass a decree to evict the defendant by dismantling the house and concrete pillar fencing illegally attempted to be constructed on the suit land described in Schedule Kho. Subject to title of the plaintiff, pass an ex parte injunction status quo decree to restrain the defendant from further constructing the houses and concrete pillars fencing illegally attempted to be built on the land described in Schedule Kho. Now, my lord will kindly come to the prayer in the present suit, my lord, that my lord will find at page 97. Second paragraph, my lord. From top. Therefore, the court, having considered the plaintiff's petition and document by establishing plaintiff's right title and passes a decree to evict the defendant from the land and the house on the land described in schedule, and to grant the plaintiff free and clear possession and pass a decree for compensation as mentioned in Annexure 10.3 of the as deemed appropriate by the Honorable Court to be paid by the plaintiff through the Honorable Court with the interest at the rate 8% per annum during the pendency of the case of the trial court with the interest of rate of 10%. Now, if your lordship will kindly come to the judgment that was passed in the earlier suit, my lords. The judgment starts from page 55. In that suit, my lord, this present petitioner as defendant contested the suit by filing written statement and counterclaim, praying for decree of possession, my lord.
Page number?
Page 55, my lord. Judgment starts from page 55. Operating portion, page 65, my lord. 65. My lord finds page 65. Down below. Order. In view of the discussions made above and the decisions reached therein, the suit of the plaintiff is dismissed on contest. Further, the counterclaim of the defendant is decreed with cost. It is hereby declared that the defendant have right to possess the scheduled land, and so the possession of the defendant is confirmed, and the plaintiffs, their man, agents, representatives are permanently restrained from interfering with the peaceful possession of the defendant over the scheduled land as mentioned in the counterclaim. Now, the
No,
schedule.
that's all right. But how do you explain this discrepancy?
Well,
Patta number. In one case, it is 33. In another case, it is 34.
well, this is the new patta number 33. Now, if your lordship will find the description of the suit land in the earlier suit and the description that in the present suit are same, my lord. The boundaries are same. That number is same. Boundaries are same. In fact, my lord.
But where is the environment that the patta number 33?
Hello.
And patta number 34 are the same plot of land.
If my lord comes to the present plane, my lord, the present plane at page 96, my lord, will kindly see. Page 96, paragraph 21. The cause of action for this suit first arose on 14/7/2023, date on which the title suit number 16 of 2012 and title appeal number 7 of 2017 became effective. Subsequent to this cause of action arise on the date until the amount specified in 10.3 is paid to full to the plaintiff, and the property excluding rooms numbers so and so is peacefully handed over to the plaintiff in a vacant and clear-foot position. Now, the plaintiff suit was dismissed. They preferred an title appeal, my lord, that was dismissed. In the title appeal, the earlier decree of the trial court has been upheld. Only with regard to the issue that was decided in favor of the defendant in the counterclaim.
Mr. Kaushik, you are not answering my question. My question is, how do you explain the discrepancy in the patta number of the present suit and of the earlier suit?
Well,
this is not the explanation, paragraph number 21.
So that's not, they are not disputing that this is the same suit length. In fact, my lord, the cause of
they
action
are
is.
not disputing that is a different matter,
My
but
lord.
you have to establish your case.
My lord,
Okay, let notice go at this instance.
if my lord finds the present plaint also, my lord, in the present plaint also, my lord, they have categorically said that the cause of action for filing this present suit has in terms of the judgment in the title appeal. Now, judgment in the title appeal, my lord, has reversed the issue in respect of the written statement that the defendant do not have a right title interest. However, their possession, the right of possession has been confirmed.
Okay, let notice go.
And they filed an execution petition for the recovery of the cost.
Heard Mr. B. Kosik, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 7/1/2026 passed by the learned civil judge, Senior Division Lochinpur, entitled such number 4 of 2024. This to be noted here that by the impugn order dated so and so, the learned trial court has rejected the petition filed by the petitioner under Order 14, Rule 2 of the Code of Civil Procedure. Where is the petition and the documents has been record? Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Interim period of the petitioner will be considered on next returnable date, list after 4 weeks.
Can it be 3 weeks? Well, the next date is on 7th of May. 7th of May for filing of the plaintiff's evidence.
Okay, 3
So,
weeks.
3 weeks.
Item 27.
May it please your lordship. Lordship, I am being led by senior counsel Mr. K. N. Chaudhary. He is on legs before court number 1. Therefore, after some time, your lordship, pass over for time being.
Okay.
Much.
Item 4. Orders. Item number 5.
May it please to your lordship. Lordship, matter may come up for admission. We have not received instruction.
Service completed here?
Matter may come up for admission. Lordship.
Service completed here?
Yes, lordship.
When?
Already they have appeared.
Heard Mr.
R.K. Mohandra.
Learned counsel for the petitioner. None appears for the respondent on call. List the matter for admission after
4 weeks.
2 weeks.
After 4 weeks, lordship.
4 weeks. Okay.
Obliged.
Sir, 4 weeks.
Item 6.
My lord, the sole opposite party appeared, my lord.
Matter
to me come for admission, my lord.
Okay. Heard Mr.
V.K. Borua, my lord.
Borua, learned counsel for the petitioner, Mr. Khandelia for the respondent. It is submitted, so we have some urgency. It is submitted at the bar that service in this matter is completed and it may be listed for admission. Accordingly, it is provided that recessal list the matter for admission after 1 week. After 1 week.
Interim order.
Interim order pass list shall containing.
Hello, my lord.
What?
Item 7.
Service is awaited, lord. 3 months have already passed, lord. I have
3
taken
months.
steps.
Have you tracked the consignment?
There is a report submitted by the registry, I think, lordship, on last order, directed the registry to confirm.
Okay. पहले से नहीं आता
Part 1.
লাগে itu নেই itu নাই
Receiver's name.
receiver
Receiver's.
ইহঁতে এইটো অফিচতো নিদিয়ে not available in the intercourse itu নহয় আমাৰ অফিচত হেৰি কৰি delete কৰি এইবাৰ to take fresh step
Fresh step.
heard Mr. Ahmed, learned counsel for the petitioner. Office note dated 2/5/2026 indicates that neither ID card nor answered notice issued to the respondent returned till date. The said office note also indicates that the registry has procured the journal of notice issued by way of speed post to the sole respondent, but the same was found to be not available in the India Post website. Accordingly, it is provided that the petitioner shall take fresh step upon the respondent by speed post and also by use of process within a week from today. Please stop there. 4 weeks. 4 weeks.
After 4 weeks. Is a fixed matter, Lordship. After 4 weeks.
Okay, as a fixed matter.
And the matter will stay till then. Lordship.
Pardon?
Matter is state. Family court matter. Stay has been
Stay order is there.
yes, there is.
Okay, interim order passed earlier shall continue. Next. It will continue.
Please, Your Lordship. Lord, today is the date fixed for consideration of interim prayer, Lordship. The notice was issued on 27/3, my Lord.
So both the parties are appeared.
I received the notice yesterday, engaged yesterday. 4 weeks time may be granted to file the affidavit in opposition.
My Lord,
Then we will we will stay the proceeding.
because today is a fix for consideration of my interim prayer, my Lord. My Lord, in fact, my Lord, the petition was filed by the wife, my Lord. She is having a child of 3-year-old, my Lord. And somehow she is maintaining her livelihood by serving as a, my Lord, junior assistant at Difu Law College. And in fact, respondent, my Lord, who happened to be the husband, my Lord, he resides at Lanka. However, he filed this petition before Sipsagar, my Lord. My Lord, at this stage, my Lord, my humble prayer, let them file affidavit. In the meantime, my Lord, proceeding may be stayed.
Okay. Heard Miss Sir?
As Chetia, my Lord.
Learned counsel for the petitioner and Miss
And Rahman.
and Rahman, learned counsel for the respondent. Miss Rahman submits that she is engaged yesterday and she pressed for granting her 4 weeks time to file objection petition in this matter. The learned counsel, the pair allowed, learned counsel for the petitioner submits that today is the date fixed for consideration of the interim pair. And he submits that the petitioner is serving at Difu Law College.
Law College, my Lord, as junior assistant.
Junior assistant, and the respondent, sole respondent, he resides at Lanka, but unfortunately he instituted the proceeding before the Court of Learned District Judge at Sipsagar.
Lord,
Why it was at Sipsagar?
Lord, his, my Lord, permanent resident is at Sipsagar, my Lord. However, the petition itself disclosed, my Lord, he is serving at Hujai, my Lord, Lanka. My Lord, page 16, my Lord, that was the
petition filed before the trial court, my lord. Page 16, para 8. Yes,
And the petitioner herein is residing at Defo
lordship.
with her minor daughter,
Minor son, lordship, having age of 3
minor
years.
son. And it is impossible on her part to contest the proceeding at Shivsagar. Para. The submission of Mr. Satya, learned counsel for the petitioner, needs further consideration. That is this further proceeding of title suit number.
Yes, M number
Title-
116 of
Title suit
2025.
M, case number 116 of 2025, pending before the court of learned district of Shivsagar, stands state till next date.
Deeply obliged, my lord.
9.
My lord, 9 is similar, my lord. Here, my lord, the case was filed for, my lord, seeking custody of the minor child. On the same date, my lord, this week's between same parties. This case number, Miss G, case number 11 of 2025. Between the same parties, my lord.
Art Mr. Satya, learned counsel for the petitioner, Mr. Rahman for the respondent. Mr. Rahman submits that you want to file objection in this petition also. That she submits that she may be granted some time to file objection in this petition. They are allowed. List the matter after 4 weeks along with transfer petition number
Lordship, 34 of 2020.
34 of 2026.
My lord, the proceeding before the trial court may be stayed, lord, in this case.
Here also.
Lordship. Otherwise, next date is on 28, my lord. That's right.
Considering the submission of Mr. Satya, learned counsel for the petitioner, and also considering the facts and circumstances on the record, further proceeding of Ms. Z, case number 11 of 2025, stands till next date.
Deeply obliged, my lord.
27.
May it please.
Yes.
My lord, the opposite party respondents, my lord, they instituted a title suit claiming right, title, and interest except of the court to the concerned revenue authorities issued. So, my lord, the prayer is that this deed of partition, etc., is bad in law. Now, my lord, please come to the next page, page 47. Schedule A is the land which the my lord plaintiff claims it to be theirs, and Schedule B is the disputed land, 1 bigha 2 kata. Now, my lord, there was an injunction petition moved way back on 12/10/2020, which order lordships will get at page 64. Now, I'll have your lordship's kind attention to page 65, my lord.
Yes.
Now, this is the case of the plaintiff, my lord. Page 65, 4 lines from bottom, my lord. The sentence starting with the defendant number 1, that is the petitioner number 1 before lordships. The defendant number 1 has illegally got a portion of land measuring 1 bigha 2 kotha 10 lechas of Dag number 4 bifurcated in his name by creating a new Dag number so and new Dag number so, and the said new Dag and Patta have been mentioned by naming Schedule B due to lack of boundary mark of encroached portion of land by each of the main defendants, and due to the common intention of the said defendant to grab different portion of the suit land by any means, all the defendant numbers 1 to 10 are liable to be evicted from each and every bit of land with Dag and Patta number. The plaintiff begs to state that defendant number 1 not only got his name mutated, but also got his aforesaid portion of the land bifurcated into another plot by creating new Dag number so, which is reflected in the remark column of the Jamabandi, and therefore there remains only 4 bigha 2 lachas of land in new Patta number 97 of the plaintiff. Some aggrieved persons had filed revenue appeal against the said illegal bifurcation of the land of Dag number 4, but such appeal are pending in the Revenue Department of the state. Therefore, the case of the plaintiff was, my lord, out of the 5 bigha 2 kotha and 12 lechas, 1 Bigha, 2 Kotha, and 10 Lecha was illegally, my lord, partitioned by the defendant. That is their case, my lord. Then, my lord, based on this, if your lordship would kindly come to page 67, second and third para, my lord. Upon perusal, consider a consideration in the light of the submission made by the learned counsel appearing for the petitioner. It appears that the petitioner has a prima facie case in hand, inasmuch as balance of convenience also lies in his favor. Also, it is not possible at this stage to determine the dispute as alleged, and the same can be determined only after hearing the other side. So, to stop multiplicity of litigation and in the heels of the above at this stage, both the parties are directed to maintain status quo. Milord, this order was passed on 12/10/2020. There is no difficulty, Milord. The learned trial court itself says that at this stage it is not possible to know. Therefore, Milord, to avoid multiplicity of proceedings, let us grant an order of status quo. That continued. Now, Milord, now, on Milord, sometimes last month, Milord, a miss case was filed at page 100, Milord. Apparently, this is an application under order 39, 2A and 7. Now, based on this, Milord, now an order has been passed, impugn order has been passed, which your lordships will get at page number 151. My ingress has been stopped, Milord, to the suit land. Both sides are represented. Today is fixed for written objection. Right petition opposite prayed for adjournment, citing reasons of illness. Hard perused. Right petition filed under section 151 CPC. Petitioner has prayed for implementation of the order dated so and so. Perusal of the case record reveals that order dated so and so. It is reflected that the report of concerned revenue circle has stated that OPs are constructing Pakka house upon the suit land. Further, while order dated, it is reflected that the report of the police in charge Amengao has stated violation of order of status quo by the opposite party, as opposite parties has been constructing a Pakka house upon the suit land. In view of the above, this court is of the considered opinion to direct OC Amengao outpost to seal the entry gate of the suit land in order to implement the order of status quo dated so and so, so and so, so and so. My humble submission is, my lord, I am residing in that place. My lord, this suit is filed seeking a declaration. There is a right title of declaration has to be there in his favor. Then it will be followed by a decree of eviction. Now, before that, my lord, I have been debarred. As far as stopping construction, okay, my lord, I am not on that. But that entry part, I am agreed, my lord. How can they agree? My entry be, my lord, barred now? And my lord, lordship knows in a contempt jurisdiction, be it civil court or be it high court, my lord, normally it should not pass a further order on the merits of the case. In a contempt proceeding, if the court finds that the person is guilty, then, my lord, appropriate punishment can be given. But to pass further orders, I don't think, my lord, this is permissible. In any case, my lord, even if we go by apply the spirit of order 39 rule 8 also, my lord, what is evident? It says preservation. What can be done is to preserve the property. So status quo is good enough. Now, my lord, how can my entry be stopped? Because in that, admittedly, there is only one entry to that. Both the plaintiff and defendant, they enjoy the same. Now, police is debarring me, my lord. I can't even enter my house. Therefore, my humble submission is, my lord, it's a material irregularity has been. That's why we invoked power under Article 227. The trial court has gone out of bound, my lord. If it's an appropriate case where lordships will interfere in and pass an appropriate, at least my entry should be ensured, my lord. All right, the court has issued an order for stopping construction. Against that, I am not before a lordship. I am only before a lordship regarding that part of the order by which my entry has been barred, my lord.
Okay. Yes.
I'm sorry to say that my senior counsel has been wrongly instructed by the clients or his lawyer. In the suit lane, there are two gates. Initially, there was only one gate on the eastern side. they had been using it when the title suit was filed in 2020. In 2021, Lordship, they violated the status quo order, Lordship, during the COVID period, Lordship. They started building a wall on the western side. We objected, we went before the police, we provided them photocopies of the construction. And finally, we also filed a petition before the court. Lordship, subsequent to the order, status quo was continued time and again, Lordship. It was continued, but they had been violating the status quo order. A boundary was constructed, and along with the boundary wall, after closing that part, Lordship, they started building a gate, Lordship. Then the gate was completed. After the gate was completed, that is in the western side that we have referred to in our petition, Lordship, in a plain Lordship. We had referred to that in the western part, there is a big gate for bringing in, Lordship, all building materials, Lordship. Dumpers can also enter through the gate, Lordship. And that is on the western side. What we had prayed for was to close down and seal the western gate, Lordship. Not the eastern gate, Lordship. They already have an eastern gate, Lordship. And the western gate is on the far side, which we cannot see from our side, Lordship. We live in the eastern part of the Suitland, Lordship. We also have residences in the same area, Lordship. That is in the western side. In the eastern side, they have a gate by the side of a wall, Lordship. They have built their own wall, they have their own gate. After building that gate, that wall, on the other side, which we cannot see, they block every sighting of the Suitland, Lordship. And started constructing therein, Lordship. Police was instructed to give status quo report to the honorable court. When the wall was initially started on the western side, police delayed it by 1 year. For 1 year, it was delayed. After 1 year, they gave a report, yes, there is a wall. In fact, while the wall was being built on the western side, Lordship, we have also given photocopies that they are building this wall. This is the photo you see. That was provided to the honorable court also. So the honorable court took note of that, Lordship. That this was a new wall, this was a new gate, and they were starting building other houses also in the Suitland. That is reported in the order itself, Lordship. As per report of the circle officer, as per report of the police, Lordship. Both things have been reported in
No,
the what we have prayed in our petition, Lordship, in a plain, Lordship, that the eastern side gate should be kept open, which was originally there. We are not objecting to it, to enter the land, Lordship, to enter the house. So western gate, through which the bring in the building materials, Lordship, a big gate, Lordship, through which trucks can enter. They bring all the materials, Lordship, stand, seal, everything, Lordship, and they walk throughout the night, Lordship. So that we cannot see through, they have built big walls, Lordship, so that no one can enter there, Lordship, and they have been using that gate. We have provided all instructions from police, as well as the deputy commissioner's office, district administration office.
so according to you, there are two gates.
Two gates, Lordship.
Okay.
Lordship.
So even one gate is closed by the court,
Lordship.
the other gate is
Will be there, Lordship. Eastern side gate will be there, Lordship.
will be there or it is there.
It is there, Lordship. We have a photo also, Lordship. Photocopy. This photograph is taken on, Lordship, 3/5/2026.
Okay.
Recent, Lordship. The gate is still there, Lordship.
91.
And the honorable court took note of that, Lordship. Otherwise, how can the honorable court seal the entry point of that house, Lordship? Honorable court took note of that. That there is a western gate which was built in violation of the status quo order, Lordship. The teen, Lordship, have seen their teen, their upbuilt wall, Lordship. That is their house, Lordship. They have a gate, Lordship.
No. Can any person enter through this gate?
Even cars can enter through it. Initially, they were using it. When they started building the house, Lordship, so that we cannot see on the other side, Lordship, the trees.
No. You answer my question whether any person can enter through this road.
Lordship. Even a car can enter, Lordship.
car can enter.
Lordship,
How?
Lordship, that is wide enough, Lordship. This road is wide enough, Lordship. Only for their own house, Lordship. There are no other houses, Lordship.
So you say there is a drain. How can the car enter through the
That
drain?
is the purpose, Lordship. That we have stated, Lordship. That we have stated while filing the. Today we have filed it, Lordship. Today the matter is there, Lordship. To frustrate the honorable court's order, they have started digging this, Lordship. To frustrate the honorable court's status quo order and the gate and the order relating to the gate, Lordship, they have started digging this, Lordship. We have filed it today, Lordship. This is a new one, Lordship. Newly constructed. Only a few days back they have started constructing. As soon as they started digging, Lordship, we took the photo, Lordship.
Which one
That
new? Which one is new wall?
This one is the old one, Lordship. This one is the old one, Lordship. That is why we took it on Sunday, 3/5/2026. We didn't know that this case is coming, Lordship. We didn't know that this case is coming.
Okay, okay.
So we were preparing for that case. So for during the preparation, we have taken the photo. We have filed our plain there, the application there today, Lordship. Today the matter is being heard. We wanted to bring into notice of the honorable court that this is being done now to frustrate the honorable court's order relating to the gate.
Okay. Mr. Sotori, there exist two gates.
Milord, Milord, your lordship will kindly come to the impugn order, Milord. Milord, lordship is not a court of fact. If there are two gates, the London trial court should have discussed all this. And where is the petition they have mentioned about two gates?
Exactly.
Now kindly see the order, Milord. Kindly see perusal of the page 151.
Yes.
Perusal of the case record reveals that by order dated 27/3/26, it is reflected that the report of the concerned revenue circle has stated that OPs are constructing a pakka house upon the suit land. But the complaint is regarding construction of a pakka house. It is not regarding construction of a drain or a road. Further, white order, it is reflected, report of police in charge has stated violation of order of status quo by the opposite party as OPs have been constructing pakka house upon the suit land. In favor of court is of the considered opinion with that to direct the OC Amingaon outpost to seal the entry gate of the suit land. It doesn't mention east or west, Miller. There is only one gate, that is the western gate. And eastern gate is not possible, Miller. We cannot use that. But all that I am praying for is my entry should not be barred. Let this suit be decided expeditiously, Milord. Should be maintained. And status, Milord, even I am not complaining regarding the order by the trial court, whereby it says stop construction. We will not do anything. Only thing is, Milord, how can, when I am living there, how do I come out and go get in, Milord? Milord, the learned trial court should have ensured to mention that there is an eastern gate. That's why I'm stopping from the western side. Oblivious of everything, can this order be passed, my lord? How can my learned friend now bring all this? End of the day, lordships will go by the facts which were taken note of by the trial court. Trial court has taken note of construction of house, not of road or digging a drain. Therefore, my humble submission is, my lord, my only prayer is my entry should not be barred.
Okay, we will pass order.
Yes.
For a moment, page 107. Page 107. There are 10.
Yes.
That after completion of the wall, this is in violation, which was completed while the status quo order dated 12/10/2020 was in force. The height of the wall had prevented the plaintiff from finding as to what was happening inside the boundary walls. Moreover, the another aspect of such fact is that during the existence of the status quo order itself, the defendant number 1 and 2 had opened and developed an approach/entry road on the other side of the plot of suit land. It is worth mentioning that while an approach road for entry into the suit land was in existence in the eastern end of the suit land, the new approach road was constructed in the extreme western end. The southern end of the approach road links them to the state PWD road, Gauhati road, and the northern and happens to be the Suitland. The newly constructed road in the western end was not at all a necessity in normal circumstances. But however, since the defendant number 1 and 2 wanted to use it in violation of the status quo order of the Honorable Court for using it for their business and other
No,
purposes,
that,
as such,
that,
the same was developed.
Mr. Bhagavate, you say that application is pending before the trial court.
Lordship,
The trial court is take note of the same after hearing both the parties.
Lordship.
Milord,
Lordship may see the prayer portion also.
Milord, my humble submission
no,
is
no,
these impugned
uh,
orders should be set aside.
We are
Matters should be
examining the
remanded.
impugn order only here.
Lordship, page 112, Lordship, is a prayer before the court, Lordship. Page 112, what we prayed for, Lordship.
Okay, we'll see and pass the order.
Only we prayed for the western side gate should be sealed.
Okay.
That was our, because the status quo was violated from 2021 onwards.
No, there is no status quo in respect of the gate.
Yes.
And you were not supposed to dictate by who is gate he will effect his
Yes.
entry and
Because there was no other way, police report was also there, that they were building new houses.
okay,
also.
okay, all right. Pass. Okay. Service completed?
Yes.
We'll fix the matter for admission then. Heard Mr. Borwa, Sarma, Learned Counsel for the petitioner, and Mr. A. Borwa, Learned Counsel for the respondent. Since service in this matter has been completed, recessal is the matter for admission hearing. After,
Lordship, date may be fixed, Lordship, because these are ex parte orders only for execution, Lordship, this case is.
cover.
4 weeks on 5th May. Sorry, 5th June. Again. 11.
May I please your lordship? Lordship, because of our own mistake, the steps were not completed in time.
Okay.
Therefore,
Pardon
non
me,
may
sir?
be granted.
Your name
And Hazarika.
and Hazarika, Learned Counsel for the petitioner. The Learned Counsel for the petitioner submits that due to some inadvertence, step could not be completed upon the respondent. Accordingly, it is provided that step be taken upon the respondent by state post and also by usual process within a week from today. Let's chapter for
The interim was there. Interim order was.
Okay, interim order pass earlier cell continue.
12.
May it please your lord. My lord, service upon the sole respondent is awaited in terms of office note dated 2/5/2026. And one more remark in the office note, my lord, is that I have not taken steps through usual process, but there is no such direction in the order. Order dated 25/3/2026, which was passed by this honorable court, directed me to take steps only by speed post with AD. So perhaps this observation by the registry is redundant.
Heard Mr. Sakurate, Learned Counsel for the petitioner. Office note dated 2/5/2026 indicates that neither edit card nor answer notice received by the section till date. So this is the matter after 2 weeks awaiting service report upon the response.
Can I, my lord, have a fixed date, my lord? After 2 weeks,
25th May.
25th, apply.
13.
May it please your lordship.
Mm.
As per office note dated 2/5/26, service may be awaited, lordship.
You are appearing for
1, 2, 3, 5, 6, 7, 8.
1, 2, 3, 5, 6, 7, 8.
Except 4, my lord.
Heard Miss
S. Musahari.
Learned Counsel for the petitioner, and Mr. A.J. Sharma, Learned Counsel for the respondent. Office note dated 4/25/2026 indicates that service upon respondent number 4.1 and 9 to 10. 9 to 10 still awaited. You want to take fresh step?
No, Lordship. As per office note, neither ID card nor answer notice has returned.
Yes. So we will await that.
Awaited, Lordship.
But in respect of respondent number 4.2,
Lordship,
return with a report.
yes,
No
Lordship.
such person returned to the sender.
I will take instruction regarding
Okay.
respondent 4.2.
Then office note also indicates that notice issued to the respondent number 4.2 returned with a report. With an inverted comma, no such person returned to the sender. Learned Counsel for the petitioner submits that she will obtain necessary instruction in this regard from the petitioner. List the matter after 2 weeks, awaiting service report upon respondent number 4.1 and 9 to 11. 9 to 11. List after 2 weeks.
Highly obliged.
Item 30.
Maybe the lordship service is completed in this matter.
Service completed.
Matter may become
Cross objective. Cross objection.
Okay. Heard Miss
Embora lordship on behalf of
Embora, Learned Counsel appearing on behalf of Mr. S.P. Chaudhary, Learned Counsel for the petition for the appellant, and Mr. Thor for respondent number
All the respondents.
for all the respondents. LCA receipt.
Yes, yes.
hearing lordship.
Okay.
Come up for hearing.
It is submitted at the bar that since service has been completed and LCR has been received, the matter may be fixed for hearing. Hearing. Accordingly, it is provided that reception list is received for hearing, along with cross objection number 50 of 2022.
Yes.
After when?
Summer vacation, madam?
After vacation.
In the month of September. Obliged.
31.
May I please, the Lordship?
Hmm.
Lordship, here inadvertently, the steps were not taken, Lordship. May be allowed
Okay.
to take steps.
Heard, Mr. Your
P.
name?
Mojumdar, Lordship.
Your name?
P. Mojumdar, Lordship.
Learned Counsel for the applicant. The Learned Counsel for the applicant submits that due to inadvertence, he could not take step upon the opposite party. Accordingly, it is provided that step be taken upon the opposite parties by speed post and also by usual process within a week from today, list after 4 weeks.
Obliged, Lordship.
Item for admission. Item number 29.
Okay, but whether the other side is present?
We are for this.
Okay, after some time.
Item for hearing under order 41. Item 4.
Please, the sheets or pass over the timing. Somebody.
Who will appear?
Mubarak.
Okay, after some time.
Items for hearing. Item 40. Final matter.
May I please, Worship?
Yes.
My lord, here the legal heirs of appellants are the party now because the appellant has already dead. The brief facts of the case is like that. A plot of land measuring 2 kata 10 lesa out of 7 biga land sold that means an agreement was executed by Nasir Khan, the present appellant, in favor of the present respondent. Now, this 2 kata 5 lesa of land, which Lordship may kindly see at page 7, operative portion may be seen at page 8, bottom. 2 kata 5 lesas of land out of 7 biga 4 kata 7 lesa covered by the number 316, 356, 360 of PP number 62 of Dimoroguri, Kisham Mouza, Nish Shahar, District Nogang, Assam, bounded by so and so. Now, originally, this plot of land belonged to Abdul Kadir, the original owner of this 7 biga of land, including these 2 kata 5 lesa. The Kadir Khan had several sons and daughters, to which I am coming later on. So, Abdul Kadir had several sons, perhaps 4, and 2 daughters. Now, my lord, the land was not demarcated, but this Nasir Khan sold the land by saying that this is my land, I am executing the agreement. So in that manner, he executed the agreement, but later on, it is their case that Nasir Khan did not execute the sale deed, so they filed. The present
No, that agreement was between Nasir Khan
and Nurul Amin.
Nurul Amin.
Nurul Amin was the plaintiff in the court below. And Nasir Khan was defendant in the court below. So when Nasir Khan did not execute any sale deed, then Nurul Amin filed title suit for a specific performance.
No, before the trial court, Nurul Amin was the plaintiff.
Nurul Amin.
Yes.
He was the plaintiff, who is the purchaser, plaintiff purchaser.
Okay.
Purchaser means agreement, in agreement to purchase the land he made.
Okay.
And otherwise we may say purchaser. Now the Nurul Amin filed title suit with the prayer that he should be given the order of executing sale deed by Nasir Khan. And in absence, the same may be done by the Honorable Court. His prayer may be seen page 8. Page 8. His prayer was like this, my lord. A decree be passed for a specific performance of contract against the defendant, directing the defendant to execute the sale deed in favor of plaintiff on receiving the balance amount of rupees so and so from the plaintiff within a stipulated time. If the defendant fails to execute the sale deed within the stipulated time given by the court, then the court may be executed the sale deed in favor of the plaintiff by receiving the balance amount of rupees 25,000.
So, what was the sale consideration?
Lord,
What was the sale consideration?
total sale consideration was so 1,12,500.
1,12,000?
500. 500. 1,12,500.
Okay.
And as earnest money, Nasir Khan took rupees 87,500. Now, balance amount was rupees 25,000, as appears from the contents, my lord.
Balance was
25,000.
yes.
Now, after filing this case by Nurul Amin, Nasir Khan submitted WS. In the WS lordship, may kindly see page 9 of the appeal. Page 9. Para 7 may be seen.
Yes.
That the suit is bad for non-render of necessary parties. All other heirs of late Abdul Qadir, namely Muhammad Nazu Khan. It is even cut. However, Kasem Khan, Mohammad Saleha Begum, and Nur Jahan Begum, and heirs of deceased sons, Nazu Khan, Nazim Khan, and Abul Khan, and also heirs of deceased daughters, namely Rejia Begum and Suraya Begum, and all other pattadars of the suit patta land are necessary parties to the suit. Now, my lord, here all other pattadars, regarding that, it is perhaps not correct, but legal heirs of Kader Khan, they are certainly necessary party.
Legal heirs of?
Kader Khan.
Who is Kader Khan?
Kader Khan is the father of Nasir Khan.
Abdul Qadir.
Abdul Qadir. Abdul Qadir is the father of Nasir Khan, and Nasir Khan says that I have brothers and sisters and they are necessary party. But at the time of filing the suit, the plaintiff has not met the parties.
Mr. Mahmood, on the other day,
Yes.
there was a discussion that in a suit for a specific performance of the contract, there are only two parties.
Yes.
So, how this legal heirs of Abdul Qadir is a necessary party?
Yes, our submission is this, my lord. First thing, this is Azmali land. Azmali land of all the legal heirs of late Abdul Qadir. Thereafter owned by Nasir Khan and other legal heirs. But here it is true that Nasir Khan executed agreement with Nurul Amin and he wrote, "This is my land and I am selling this plot of land to Nurul Amin." That is incorrect statement. There is a provision in CPC, I am coming to that point later on, that if the plaintiff says something which is not legal, the court should reject the plaint. Now, I am claiming.
No, whether you have made any such averment before the trial court.
No, let us go to agreement for a while. Agreement for a while, what he wrote in the agreement.
In second appeal, you cannot raise a new question.
No, these are the not new question. This is the statement in WS. Wrong reading and misreading of evidence is also a substantial question of law.
Where, in which part of your WS such play is taken?
Page 9, kindly see. Page 9, para 7. That the suit is bad for non-joinder of necessary parties. All other heirs of late Abdul Qadir, namely so-and-so, are not made parties.
Where, whether any issue was framed on this point?
Yes. Yes. Regarding issue, I wanted to come later on. However,
No, not later on. You come directly to the issue.
Yes.
Whether any issue was framed.
Kindly see page 25.
Yes.
Bottom, para 9. On the basis of the aforesaid pleadings, the learned court below framed following issues: whether the suit is maintainable, whether the defendant made a contract to sell the land mentioned in Schedule A to plaintiff and also executed a deed of agreement for sale bearing number so-and-so, whether the defendant breached the terms and conditions of the agreement, whether plaintiff is entitled for a relief as sought for, to what other reliefs the plaintiff is entitled for. So, that was not the issue.
No issue was framed.
Regarding?
And rightly no issue was framed because the agreement was between two persons only.
Yes. No, that cannot be valid. I have.
This is a suit for specific performance of contract.
Maybe. But against this, I am claiming something which I have no legal right to claim. And here Nasir Khan is saying this is my plot of land. And accordingly, I am executing the sale agreement with so-and-so. But actually, Nasir Khan is not the owner alone. He definitely has a share. So, the very statement in the agreement itself is wrong. And when there is wrong?
No, whether you have challenged that agreement.
No, agreement I cannot challenge.
How can you raise that point?
I cannot challenge. Legal heirs may challenge, and I have been told, I have been told that already there is a case challenging the validity and legality of the agreement for sale. Already there is a case. Now the other legal heirs have made this case, filed this case. Whether they have filed or not, I have no clear idea. But they have said that we are preparing to nearly 1 week back that we are filing. Now the question of regarding condonation of delay, that is the matter to be decided by the trial court. So, non-framing of issue, whether the present appellant, Nasir Khan or his legal heirs, have the right alone. But this is very important point. Whether Nasir Khan or at present his legal heirs have the right alone to make an agreement in respect of Esmali Patna land without having been partitioned.
No,
Now
he
here,
can-
the Honorable Supreme Court, Lord,
He can
that-
sell his part.
my lord,
He can sell his part.
his part he can sell.
Mm.
But the contents of the agreement is that I am absolute owner. That is why it
No,
was
no, in this specific performance, suit for specific performance of contract, the court has to see only the willingness and readiness on the part of the parties to perform the part of the contract. Their part of the contract.
let me satisfy your lordship.
Like a regular title suit, we cannot go into the matter.
If he can sell his share, but here 2 kata 5 lesser, and legal lesser already I think 7 or 8. Then what will be his portion? If 7 is
No.
there,
We cannot determine the part of the share of other persons.
no, well, this is very pertinent and
Maybe
very
this
legal
is second
question.
appeal, Mr. Mahmood. This is second appeal.
Second appeal, that is why this is a legal point. Second appeal means what? Some law point which is important but not discussed. What is the meaning of separate? Let me clarify. It is said that when the matter is very much important or a legal question is there, but the issue was not framed and that was not discussed. That was not discussed and arrived in a conclusion. That is the one of the main ground of second appeal. Here that issue was important. And second thing is this, whether the agreement was legally sustainable. Because this is Lotashil, for example, madam, for your Lotashil playground. Now, suppose it is the property of 4 brothers. Now, I being one brother, I cannot execute the deed of agreement for sale because my other 3 brothers are there. Either it should be partition or both 4 shall have to execute the agreement. So this is the question of law that is discussed by the Honorable Supreme Court also. Let me.
Maybe Mr. Mahmood, you say this suit is for specific performance of the contract.
Yes,
This
it is also
not
it is a case.
not for declaration of right, title, and interest.
That maybe if I have no right,
We
how I
cannot
can transfer my right.
No, we cannot deal with the issues raised by you in a suit for specific performance of the contract.
In such a case should be remanded. That is there is also satisfied. I am satisfying your lordship. Here, right title, your lordship has said that a specific performance of contract.
No, you
But
see
when
the
I have no right.
No, Mr. Mahmood, you see the plain, the pair portion. Page number 8.
Yes, page 8. Yes. A decree for past for a specific performance of contract. That
This
is also
not
my
for
question.
your right, title, and interest.
No, right title interest is hidden here.
No.
It is hidden.
Then, Mr. Mahmood, if you argue in this line, then Mr. Mahmood, perhaps we will not be in a position to accept the same.
No, my lord, if lordship would be satisfied fully, I will satisfy your lordship.
No.
Because if I have no right, then how I can transfer my right to other person? First, I shall have to get the right. It is my book. This is my book. I have ownership right over this book. Then only I can sell it to him or her. But here, he has no absolute legal right. How he can transfer the right to others?
You go and challenge the agreement before the trial court by filing a separate suit.
My lord, I am submitting one judgment.
Hmm.
Of course, I am sorry. It may be someone here. What is that? Golam Lalchan. This is it is Savo kindly. 2024. INSC 676. আগত কি আছে না আজি তো দেন কোন কোন এবার দাঁড়া তুমি লিখে এইটা করা my lord, here lordship in this judgment I am reading that 2024 INSC 676. Here lordship I am reading the operative portions, my lord. Para 3. Lordship may kindly hear. The plaintiff respondent Nandulal claimed that he had acquired rights in the aforesaid property through his father, late Salik Ram,
No,
along
that's,
with
Mr. Mahmood, first we have to ascertain what was the suit in that matter.
in that matter the specific performance of contract. This one person, in spite of other legal heirs, executed the agreement, and the lastly the Honorable Supreme Court said, let me go through this. Para 24 and 25. The suit property which is undivided is left with the co-owners to proceed in accordance with law to get their shares determined and demarcated before making a transfer. Before making a transfer, the point for determination formulated in paragraph 12 above is accordingly answered, and it is held that Brismohan alone was not competent to transfer the entire property without getting his share determined and demarcated so as to bind the other co-owners. According to the defendant appellant S.K. Gulam Lalchan has rightly been restrained by the decree of injunction in acting in derogation of the property rights of the co-owners until and unless the partition takes place.
That was at what stage of the proceeding?
My lord.
At what stage of the proceeding that?
It is in Supreme Court, my lord. Several 2 or 3 times it was there. First
No,
trial court.
we are not at the stage of granting injunction. We are in second appeal now.
In second appeal, that is a question of law, my lord. Question of law can be raised for the first time even in Supreme Court. And our High Court says that new plea can be also raised.
In which matter?
New plea.
No, that's all right. In which matter this High Court has said?
New pleas can be raised.
Yes.
Yes, they are the division bench judgment, my lord.
Division bench judgment.
My lord Justice Brijesh Kumar passed the order. Of course, today I have not brought, but if your lordship desires tomorrow,
you produce it before this court.
Yes, my lord. I will definitely give.
You produce it.
Kindly say para 23 and 24. Exactly like our case.
No, this is not a suit for specific performance of the contract. This is a right title interest. Declaratory suit. Not suit for specific performance of the contract.
But my lord, I am submitting. Very question.
This judgment will not help you, Mr. Mahmood.
My lord, the suit for a specific performance of contract. Here also right is looking, secretly there is right. Because I cannot make any agreement with a property which does not belong to me alone.
No. That submission cannot be accepted here.
And Lordship would see here, this is the, it may be in the lower court record, but we have also got. Kindly see the mutation. There are so many persons named in this land.
Maybe we cannot go into that aspect.
Now, the substantial question, my lord, was that proper issue was not framed. Proper issue was not framed. First one is that whether regarding Ahmedabad Municipal Corporation, your lordship the other day said, I have also brought that judgment. My lord, proper issue would be here. Two issues should be there. And I think this Honorable High Court for substantial justice should frame two more issues. Whether the appellant alone had the right to execute an agreement for sale with the respondent when the suit property are the properties of various persons without making partition. My lord, because this Honorable High Court is a court of record, my lord. The other day, exactly in similar case, my lord Justice, that is, I have another judgment, that is one judgment that was my lord Shovita Rani Saha. I am giving the judgment. Shovita Rani Saha and some Brahmo. Our High Court decided that in such a situation, the agreement was no doubt made, but in view of a judgment that I have already told that the party is entitled to get the paid money, already paid money, even interest was also not paid. Shovita Rani Saha versus some Brahmo, that my lord I am coming. So, only the principal amount which is paid by the defendant, by the appellant, that was asked to be paid, and that too without any fixed date. Of course, that's why case has been now, review petition has been filed, because when the money would be returned back, that is not mentioned. Now shall be, that person shall be always at the mercy of the defendant. So review has been admitted.
No, Mr. Mahmood, you come to the present case now.
So, my lord, when the CPCB section 41, right? Section 41. 41. CPC. Here it is said, my lord, in order 4 to violation, order 4. Order 4. Order 4. Order 4. Rule 4. My lord, I will show this, that provision of law. When something a person has claimed, but he is actually not the absolute owner, then the court at the first instance should reject the plaint. So that was not done. So that is one
No,
of
whether you have, whether any such application was filed before the trial court for rejection of the plaint?
that is
Not there.
That
Not
was
there.
not. But petition may be filed or not. The court has the discretionary power.
No,
And your lordship
no.
knows that discretion should be exercised
No,
in accordance with
Mr.
law.
Mr. Mahmood, this is second appeal. We are dealing with substantial question of law only. You see, this is on Kasturi versus Aya Perumal and others, 2005-6 SCC. Here a Supreme Court has stated that only the necessary parties are those parties who are parties to the contract.
But yes, that is correct. But
Then
here the property belongs to several persons.
maybe.
And my judgment is my lord 2024, and it is 2005. What your lordship has pointed out,
Yes.
it is the judgment of 2005.
Which one will prevail? This
Later
is
on,
of 3-judge bench. And in view of the doctrine of precedent, the former will prevail, not the latter one.
my lord, it is said by the Honorable Supreme Court,
Hmm.
the law is the last order.
Where
passed
it is
by the
stated?
last judge.
Where? You see the constitutional bench decision in the
This
case
is
of
common
National
practice.
Insurance Company
Suppose
Limited
learned
versus
second judge has convicted a person. High Court has acquitted. Then automatically the latter part will prevail over the former part.
Hmm.
So law is the last judgment passed by the last judge.
Okay, you produce that decision before this court. We will resume after 5 minutes.
Definitely I will produce. My lord, I have one humble prayer. Actually, my juniors came very late today. Kindly fix it on Thursday. I'm not taking long date. Only day after tomorrow.
This court is not sitting on Thursday.
Then when your worship would say that the first day,
Heard Mr. Mahmood, learned counsel for the appellant, and Mr. Dotto for the respondent. Argument of Mr. Mahmood remain, and he pressed for granting an adjournment. Pair allowed. Place the matter.
June. 16 June. The quarter matter.
Yes, this is a, yes, sir, it is started.
There are 9.
I love like.
9. Because what has happened, my lord, this, the house in which the petition, the respondent is staying, my lord, now they want to repair it. It's dripping, the rainy season has come. That is, that is the difficulty. There is in fact an application also I filed earlier, which was not again to be taken into consideration.
That's all right. We are ready to hear the matter, but he is taking time.
Other day also the time was taken after that when the matter was
Yes,
hard at length.
no further time will be granted to you.
9 June. 9.
Sorry,
Sorry. 9 June.
sorry.
2nd June.
Second, sir.
2nd June.
Okay.
Third item, 4. Or regarding under order for 4.
Maybe lordship. Lordship, on the last occasion, lordship, your lordship. As the respondent, my lord, to have some judgment, my lord. Regarding section 7, my lord,
Yeah.
and 20 of the Family Court Act, my lord. And I have also realized the version of our High Court and as well as the Apex Court, my lord. Now, whether the civil judge junior division or munshi have the jurisdiction to entertain the matrimonial case, my lord. In the Apex Court judgment, my lord, paragraph number 7, my lord, it is clear. And the Family Court Act, section 20 is there.
Mr. Dekka,
Yes.
have you
Yes, my lord.
seen this the decision?
Yes, my lord, I have done some preparation, my lord, and last time my learned friend realized some citations, my lord. I also the citation from him, my lord. So I will also like that citations and some other citations I have brought today. So
Okay.
lordship, my learned friend is on last occasion, my lord, placed two substantial questions of law regarding the maintainability question, my lord. And when so, my lord, both the trial court, my lord, has decreed in my favor, my lord. Since that this question has raised for the first time before this court, my lord. And my lord, now question is, my lord, regarding those judgments, my lord, jurisdiction question is involved, my lord. So far jurisdiction is concerned, my lord. 5 citation, 5 case laws, my lord. I will like what. What's that? Okay. I'm waiting. My lord, this judgment I will take later, my lord. First one judgment my learned friend has relied. That is on 2025 Supreme Court MP1, that is
party's name is Muhammad Shah versus Srimati Kandani Begum. He is my guardian friend replied paragraph 12 of that judgment. That judgment first me upon this paragraph 12. To Maji reply yes.
No, no. Today he has given another judgment.
But I don't know. I have no idea.
2016, 13,
Yes, Milo. This judgment also I also reply on this judgment.
Okay.
But the last occasion, we got this judgment relied my landed friend below, paragraph 12. Whereas I will rely paragraph 9, 12, and 13 below. Paragraph 9 and 13 also of the judgment.
Who is judgment?
That is below Muhammad Shah versus Srimati Kandani Begum. 2025 for Supreme Court MP1.
Is not available on the record.
Last occasion, my landed friend is placed. I will detail that as well. Well, one more. My landed friend is right only paragraph 12, but I will rely on paragraph 9.
No, this is of Madras High Court.
Yes.
You say this is a decision of Supreme Court.
Supreme Court.
But the Supreme Court question I come lot because my
No, you come to directly come to the Supreme Court
And
decision.
in Supreme Court, my landed friend is right paragraph 7 and 8, section 20 of the Family Court Act, but section 20 when applied, when it is some section 20, suppose, in the concerned district, there's a despite the ability of family court, if the some every person file any case before any subsidiary court or district court, then section 20 says the Supreme Court is Supreme Court establishment must be there on the concerned district, But here, admittedly, in the Karimganj, there is no such family court, Section 20 come when only then family court, despite the ability of family court, but instead of coming to family court, the concern every person filed the suit before the other subordinate or before the district forum, But here, Supreme Court is saying that section 20, when it is a family court is there, then family court is overpowered, can exercise some other law, But my case is section 20 is not attracted, But admittedly in Karimganj, there is no family court, So section 20 not comes in my case, Therefore, other sentences I'm going to rely on in my support, Section 20 not come in my case. And it means there is family court in the Karimganj, despite the ability of family court, if I, instead of coming to the family court, I go for other forum, then section 20 attract, then I don't have any case there. By admittedly, there is no family court, so section 20 not come, so this citation is also not come, I appreciate the citation right when landed friend, but subject to the situation, fact, and written different, My case is
No,
not.
Mr. Dekka, you say where family court is not there,
No.
then this suit has to be instituted before the
District Court.
district, in the
District
court of district judge.
There is a section 7, and 8, that is subordinate consortium. I will read again, section 7 and 8 of the Family Court Act, District and subordinate courts also there. Since subordinate courts forum is also available, so under section 2 of the Resource of Muslim Marriage Act 1939, I directly approach before the trial court, and then that orders appellate before the district court. Then after district court, second appellate come before this court. Even some other high court, Mumbai High Court, and some other high court, the second appellate states also come to similar situation below. So some citation I will write, it is covered my case below.
Where is the citation?
Yes, I have given just now. First citation I will write below. That is Madras, that is party name Salam versus SB Syed Jafar. From High Court website, we have taken the document below paragraph 7, 8, 9, 10, 11, 12.
Yes.
Paragraph 7 below. The Act 1939 is simple enactment with 6 sections, of which Section 1 speaks about the short title and extent. Section 2 speaks about the grounds for decree for dissolution of marriage. Section 3 speaks about the notice to be served on heirs of the husband when the husband's whereabouts are not known. Section 4 speaks about effect of conversion of another faith. Section 5 speaks about the right to dower not to be factored, and Section 6 was repeated by the Section 5 of the 37. On going through this provision, it is clear that there was no provision in the Act as to in which court a suit for grant of decree for dissolution of marriage can be filed by a Muslim married woman under Act 1939. Therefore, there is no specific mention about the subject matter of jurisdiction. Section 15 CPC runs as under. Next page, Lord. Every suit shall be instituted in the court of lowest grade competent to try it, as there is no mention in the Act 2026-1937 as to in which court the suit for dissolution of marriage has to be filed as per Section 15 of the it can be filed before the district municipal court have territorial jurisdiction. Para 8 minute. Insofar as the case in the hand is concerned, there is no dispute. The case for action allows the plaintiff to file the suit within the territorial jurisdiction of district municipal court. Madura Kantam is already observed the Act 1939 did not specify as to in which court the suit for dissolution of marriage can be filed by the Muslim married woman, and that there is no other enactment regulating the filing of the suit for dissolution of Muslim marriage. Thereby, the plaintiff has to necessary to file the suit for dissolution of marriage before the district municipal court censure. The district municipal court Madurakam has returned the plaintiff to file the suit in proper court by quoting the decision of this court between reported that it's censure. And this court has carefully gone through the judgment. Facts of the case in referred judgment go to the show. The suit was filed by the Muslim person for recognition of the mutual consent divorce Mubarak. And this court in the same judgment directed the petitioner to approach the family court as per section censure. The section 7 1 be right here. Directly come to me, Lord. Para 11. It is not clear, as per the fact in judgment report above, whether the territorial jurisdiction of family court situated in the Kanchipuram district will have the territorial jurisdiction extending to the territorial jurisdiction of the district municipal court Alander. Therefore, even if the subject matter in respect of the filing a suit of dissolution of Muslim marriage under 39 has to be filed in family court, since there is no family court extending the territorial jurisdiction up to the district municipal court censure, the family court in the censure district will not have territorial jurisdiction to entertain suit for dissolution of marriage under Section 39. The relief sought by the petitioner is to pass a decree for dissolution of marriage on the ground of plurality. The plaintiff has valued relief of censure under Section censure Tamil Nadu censure. The district municipal court has not questioned the valuation of the relief mentioned the plaintiff in the plaint. Therefore, considering the Section 15 of the CPC, that is Section censure of the Tamil Nadu court fee censure, filing of suit for dissolution of marriage under 39 at district municipal court is proper. In view of the above, civil litigant petition is allowed, directing the district municipal to receive the plaint and censure and proceed accordingly. My second suggestion would be in law. That is, yes, Madhya Pradesh. One Madhya Pradesh, tell me lot.
Yes, it is available before this court.
My lord, I don't have, Sanit, my copy I have, lord.
Which paragraph you are relying on?
That is there. Madhya Pradesh. My lord, that. Oh. Yes, my lord, it is. No, oh, sorry, my lord. Bombay High Court, my lord. AI 2018 Bombay 282. Paragraph 9, 10, 11, 12.
Yes.
In the second appeal, however, its contention is advanced for the first time by the learned counsel for the appellant by submitting that when admittedly as per the title of the suit filed before the trial court, it was simpliciter suit filed under Section 2 of the Act. The trial court was not at all competent to grant any of the above said relief. It is submitted that the separate forums are provided for seeking this relief, as those rights are granted under various other statutes. According to learned counsel for the appellant, as the trial court has thus exceeded its jurisdiction in granting such relief, it is a substantial question of law which is required to be decided in the second appeal. Normally, when the objection to the jurisdiction of the trial court to entertain and grant such relief is not raised before either before the trial court or even the first appellate court, this court in the second appeal cannot entertain such objection, as it is too late in the day to do so. Because after subjecting himself to the jurisdiction of the trial court and contesting the suit in the first appeal also on merits, now as the certain reliefs granted by the courts below are against him, the appellant is raising this contention for the first time, and therefore such contention needs to be rejected outrightly. However, as the learned counsel for the appellant has advanced extensive submission on this issue, mainly on the count that if any relief is granted by the court which it was not having jurisdiction to grant, then not only such court has acted without jurisdiction or exceeded its jurisdiction, but such decree also becomes null and void. This second appeal is heard and admitted on the substantial question of law only, which is the premise below. Whether in this suit filed under Section 2 of the Dissolution of Muslim Marriage Act 1939, the civil court was competent to grant the reliefs in respect of maintenance of the children and matrimonial property of the parties for which other statutory enactment and the other forms are available. In short, the question for consideration is whether both the courts below have committed an error in granting this relief to the respondent when admittedly the suit was filed under Section 2 of the Dissolution of Muslim Marriage Act. This is, my lord, next. Paragraph 15 and 16, my lord. Thus, it is submitted, the entire act is conspicuously silent as to the right of married Muslim women towards the matter, maintenance or matrimonial property. In such situation, according to learned counsel for the appellant, in a suit filed under Section 2 of the said Act, the respondent cannot claim other relief like maintenance, meher, or share in joint property, owner property, nor the court is also competent to grant such rights or reliefs to her. According to learned counsel for the appellant, respondent may be having those rights under other enactment, like the right of maintenance under Protection of Women Domestic Violence 5 and under the Muslim Women Protection of Rights and so. But such rights cannot be granted under Dissolution of Muslim Marriage Act 39 because the rights under those two enactments, like the protection of women from domestic violence and Muslim Women Protection Divorce Act and so, are available under different fora. For getting those rights, the competent court, judicial magistrate, first class or family court, or not the other civil court, where this suit is filed. According to learned court for the appellant, therefore the trial court had exceeded the jurisdiction for exercise the jurisdiction which was not vested in it while granting this relief and responded. Finally, last paragraph, my lord. 16. It is submitted by the learned counsel to the appellant that as regard the decree of dissolution of marriage granted by both the courts below, the appellant is not having any grievance. The appellant is also not pressing the grievance in respect of the order relating to the return of the measured amount, as has already been returned the same. However, as regard the relief of maintenance to the children and in respect of granting share to the respondent in the joint family own flat, an appellant is having real grievance because the relief sought not have been granted and the trial court has confirmed by the appellant. Ultimately, court's finding below at page 37, para 37. This matter comes to this second appellate stage, whereas he stated dissolution of marriage, he has no grievance so far as, but that civil court has no jurisdiction so far as maintenance is concerned. It is his state, The point to be stressed is para 37, The point to be stressed is that in the course of matrimonial proceedings, all the disputes relating to the parties are, as far as possible, required to be brought under one umbrella and one forum, instead of driving the parties to various forums. If the family court can decide such dispute, the civil court, which is considering whether to grant decree for dissolution of marriage, cannot be said to be devoid of jurisdiction to grant the relief of maintenance and right of matrimonial property. My second petition would be below. That is 2025, that is Madhya Pradesh below, that is Muhammad Shah versus Chandan Begum, paragraph 9, 12, and 13. Very purpose of the section 13 enactment, which is discussed on section 12, para 9, my lord. May I read, my lord? This is a case where a Muslim male showed dissolution of marriage, my lord. As per section 2 of the Act of 1939, a woman married under Muslim law shall be entitled to obtain a decree for the dissolution of marriage, her marriage, on any ground as enumerated in section 2 of the Act 39. Here it appears from the perusal of the provisions as contained in the Act of 39 that a male does not have any way to obtain the decree for dissolution of marriage. For that purpose, one has to take recourse to the Act of 1984. This is Family Court Law. Section 7 of the 1984 is what reproducing in this regard. The paragraph 9, it is clear that section 39, section 2 can exercise by the only Muslim woman, not the male member. Now, my lord, paragraph 12. Rule 9 to Roman 7 is framed in respect of suit or proceeding arising out of personal law applicable to the Muslim, including the Sharia Act and the Act of 1939. The perusal of these acts and rules reveals
No, that rule is in connection with the Family Court Act.
Family Court 84 Family Court Act. It is stated this only Muslim women can have the right to file under section 2 of 1939 Act, but male member has no right. But here in this case, the male member only right under Family Court Act, but the whatever section 7 is concerned, 84 milot, the district or family court. But only the woman is concerned. Specific woman can file under 39 Act before the.
No, in the present case, who filed the case before the
My
message?
wife, I filed before case milot. I filed under section 2 milot. I am the wife. Then
Okay, then, Mr. Deka,
my lord.
okay.
My lord, may I submit humbly submit one thing, my lord. Lordship may admit, my lord, one substantial question, Lordship may fix a final disposal of the matter instead of disposing today itself. My lord, some other question will come. So one law may be framed today if a lordship. Then, my lord, final detail thorough argument is necessary in this matter.
Okay. Heard Mr. Mubarak, learned counsel for the appellant, and Mr. Deka, learned counsel for the respondent. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 30th August 2023, passed by the learned civil judge senior division Karimanganj in title appeal number 11 of 2022. It is to be noted here that by the impugned judgment and decree dated 30/8/2023, the learned civil judge Karimanganj in title appeal number 11 of 2022 had affirmed the judgment and decree dated 18/7/2022 passed by the learned Munsik number 1 Karimanganj entitled suit number 104 of 2017. Peruse the memo of appeal, the grounds therein, and also the suggested substantial question of law, and also gone through the impugned judgment and decree dated 30/8/2023 passed by the learned First Appellate Court, and also the judgment and decree dated 18/7/2022 passed by the learned Munsip number 1 Karimanganj entitled suit number 104 of 2017. This appeal is admitted on the following substantial question of law. Whether the judgment and decree so passed by the learned courts below dated so and so suffers from perversity. Moving past the same, traveling beyond the pleadings. And also without considering the pleading and proof. And number two, whether the learned first appellate court is justified in dismissing the appeal and in affirming the judgment and decree passed by the learned Munship number 1 entitled suit number 104 of 2017 on the ground of jurisdiction in absence of jurisdictional family court. Admit, no, to colon admitted on following substance and principle. Issue notice to the respondent. I'm reading it. Returnable in 4 weeks. However, no formal notice is required to be issued since Mr. Decker entered appearance and received notice. However, extra requisite copy of the memo of appeal and relevant documents be furnished to him during the course of the day. This is a call for the record from the learned courts below. List the matter after 4 weeks.
Much better.
Mr. Decker, are you going to press this IA? Not necessary.
IA is the Lordship, this admitted lordship will stay. And my only submission, my lord, after receiver elsewhere, this matter may be instead of keeping pending, my lord, hard this.
One IA is disposed of already.
Already disposable.
And another IA?
Stay.
For stay, my lord.
Stay. Okay. Heard Mr. Mubarak, learned counsel for the appellant, Mr. Decker for the respondent. This application under Order 41, Rule 5 of the Code of Civil Procedure is preferred by the applicant for staying operation of the impugned judgment and decree dated so and so passed by the learned first appellate court. Mr. Mubarak submits that the appeal has already been admitted by this court after formulation of substantial question of law, and the record has also been called for. And in that way of the matter, there is a requirement of staying operation of the impugned judgment and decree till disposal of the appeal. Mr. Decker submits that he has no objection in the event of staying that judgment and decree passed by the learned first appellate court, since the second appeal is already admitted for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, this IA stands to dispose of and operation of the impugned judgment and decree dated so and so stands state till disposal of the RSA.
My humble prayer, my lord, in the main case, my lord, after receiving the LCR, my lord, the hearing may be disposed.
Okay.
Some observation. Otherwise,
On receipt of LCR, the SSL lists the matter for final disclosure.
this deep law.
It ordered delivered.
Already disclosed. It ordered
It is good for.
I'm 29 for admission.
May I, Lord?
Yes.
The gist of this case is, my lord, the respondent, being a plaintiff, has filed a suit for performance of contract, specific performance of contract. And when they have been filed the suit has filed without any documents.
Without any?
Documents. Without any documents, annexes. Then, in respect of the suit, the defendant has filed written statement. And in this way, at the time of the hearing, they have annexed some documents. Then when we have come to know that without the documents, we have filed a written statement. That we wanted to file amended written statement. Then also, the line of trial court allowed to cross-examine to the defendant, to the plaintiff. Accordingly, we have crossed. Then, Your Honor, we have filed an application before the learned trial. For filing written statement, amended written statement, or additional written statement, as well as to re-cross-examination of the plaintiff, that is the PW1. The Honorable learned trial court has been dismissed this petition, both these petitions. And against that order, we have come before the Honorable Court for under Article 227, read with under Section 115 of CPC. This is my appeal before the Honorable Court. The impugn order at the time of filing of the suit, my lord, although they have paid for the injunction, but there is no any injunction petition under Order 39 Rule and 1 and 2 of the CPC. That the learned trial court, without giving the opportunity of my plaint, of my defense, the court is going to dispose of the case, for which we have come before your chiefs.
So you are the defendant in the trial court.
Trial court. We have filed, that is the suit is come at page 16.
So the plaintiffs file application for amendment of the plaint.
Plaintiff, defendant.
Defendant file.
After cross-examination, my lord. If your lordship, I'll just 1 second, my lord, I'll clarify the position.
No, first let him complete thereafter.
Oh my God.
Yes.
My lord, they have, when they have filed the suit, they have no any documents has been annexed with the suit.
No, your amendment application was allowed or rejected?
Rejected.
Rejected.
Rejected, as well as.
And at that time, the suit was pending for cross-examination.
Cross-examination. Now, already has been crossed. Crossed.
So whether at that stage the amendment is permissible or not?
At the time of permissible, my lord.
Permissible.
Permissible. And permissible as because if when the written statement has been filed without going through the document.
No, whether you have taken such a plea in your written statement.
A written statement has been, they have not, does not know about that they have been, some documents has been filed. They have filed the documents at the time of filing the suit as in filing some slips. They have not annexed with the, at the time of the serving of the notices.
No, you have received a copy of the plaint without any document.
Without any document.
whether you have taken such a plea in your written statement.
Yes, that is my lord, that we have taken the plea that we have filed.
Where is your written statement?
Written statement at page, my lord. 27, document number 3.
27. Yes. Which is the relevant paragraph?
Yes, I am coming. Page 35, my lord.
35.
Paragraph 32. That the answering the defendant craves leaves to of this honorable court to file an additional or amended written statement if subsequently any necessary document is required to furnish or a material facts that or any unknown material facts came to the knowledge of the defendant during the pendency of the instant case. Specifically mentioned.
No. My question is that the suit was filed without any document.
Yes.
To that effect, whether you have taken any plea in the written statement.
This is the my lord, we have been Graves
No,
leaves.
this will not cover your case.
Graves leaves, my lord. We have taken the Graves leaves before the honorable trial court.
No. This statement is not in respect of non-filing of any document along with the plaint.
Right. And subsequently, they have filed the documents at the time of the hearing, my lord. When they have the evidence has been submitted, then they have been submitted those documents. Then we can come to know that some documents.
No, then whether you have filed any objection in accepting those documents by the trial court.
No, that is, they have been filed. We have been, at that time, that has been, when it has been came to know, then we have been filed an objection petition. And against the said objection petition, they have been, the line trial court not accepted it. And we are not able to cross-examine to the plaintiff who has examined as a PW1.
When where is the application for amendment? Let us say.
That is, my lord. Document number 10, my lord, page 64.
64.
That at 64, my lord. And an application under section 153 and order 6 rule 17 read with section 151 of the CPC. Then, my lord, we have been mentioned in here. May I go through, or my lord? That the above noted suit is fixed on today before your honorable court. That the defendant petitioner hereafter referred as petitioner in the old ailing widow and in at present living at the aforesaid place mentioned in the above, that the plaintiff filed a suit against the defendant for specific performance of contract of for sale, injunction, and other consequential relief against the petitioner upon the scheduled suit land, which scheduled land is in the name of the petitioner, and the petitioners have the right, title, and possession of the scheduled suit land. That the plaintiff filed this suit illegally, unlawfully, and fraudulently in collusion with others against the petitioner for unlawful gain. That the plaintiff filed the plaint suit before your honorable court without any annexures, that is documents, although in the plaintiff mentioned about many documents in the plaint relating to the suit of the plaintiff. It may mention herein that the defendant came to know that the plaintiff, who was known to the petitioners, family, filed a case before your honorable court and accordingly appeared before your honorable court without receiving notice from your honorable court, that after appearing in the case, your honorable court directed to the plaintiff to supply the plaint to the defendant and accordingly supplied a copy of plaint only without any documents relating to the suit. The petitioners filed a written statement objection denying the averments of the plaint against the suit before your honorable court as the plaint filed by the plaintiff. It is pertinent to mention herein that the plaintiff at the time of filing affidavit on evidence as many as 10 documents filed before your honorable court, and those documents are exhibited later on before your honorable court. The said exhibited documents are not sustainable under the law. The documents are manufactured documents made fraudulently in collusion with others illegally and unlawfully, and for unlawful gain. The plaintiff misrepresented to your honorable court as the plaintiff not filed the suit with clear hand, that the petitioner as well as the advocate for the petitioner came to know from the present position of the suit, discussed with others as well as advocates about the suit, and for which a new advocate is engaged on today for the suit, and after going through the record, filed the petition for amendment of the pleadings written statement filed by the petitioner for determining the real question of controversy between the parties for just and proper decision of the suit. For the interest of justice, it is further submit before your honorable court that for the fault of others, the petitioner should not allow to suffer, that those documents are exhibited and not marked before your honorable court. The said documents, the said exhibited documents are not sustainable under law. The documents are manufactured documents made fraudulently in collusion with others illegally and unlawfully for unlawful gain. The plaintiff misrepresented to your honorable court as the plaintiff not filed the suit with clear hand, that for determining the real question relating the contract and agreement in respect of the owner of the land, that is right, title, interest and possession of the scheduled suit land, and the petitioner with the plaintiff may be decided by your honorable court, which is the real issue of the suit. That as the plaintiff is not appeared nor enclosed the documents in the plaint, and accordingly without able to do it, going through the documents, filed the written statement objection against the suit, and also the documents exhibited by the plaintiff which are not supplied to the petitioner, that is the defendant. As such, the petitioner is required to file amended written statement / objection against the suit filed by the plaintiff, and also for which your honorable court may pass such orders to supply the exhibits filed by the plaintiff, that is the witness number 1. That the plaintiff filed affidavit on 10/2/2025 with some exhibits, which exhibits documents are not annexed, enclosed with the plate. The exhibits are not marked as exhibit on that day, that is 10/2/2025. This is the interesting one. But later on, by the order dated 35/2025, after 3 months, my lord, allowed to mark the documents as exhibits. After that is after then 3 months, that the petitioner begs to state that the documents are allowed to exhibit by your honorable court. As such, the written statement filed by this petitioner, defendant is required to amend or to file additional written statement. The petitioner also craves leaves to file additional or amended written statements as and when necessary as the time of filing written statement, that is on 16/5/2024 against the suit. That for the just and proper decision of the suit and also for determining the real question is controversy between the parties, the defendant is necessary to file additional written statement against the suit, otherwise justice would be prejudiced. That for the purpose of determining the issue raised by the plaintiff in the plaint and also for the ends of justice, as well as to prevent abuse of the process of the court, the petitioner is required to file additional written statement or to amend the written statement by the petitioner against the suit, and accordingly issues for this suit also would be necessary to frame for just and proper decision of the suit. That the petitioner begs to state that if the petitioner is not allowed to file additional written statement or to amend the written statement filed by the petitioner shall suffer irreparable loss and injury. That this application is made bona fide. From the above facts and circumstances, your honorable court be pleased to allow the petitioner to file additional written statement and allow to amend the written statement filed by the petitioner or as defendant in the suit against the suit filed by the plaintiff. This is the one application. Then we have another application has been filed, that is for that against that application, they have given some, the plaintiffs have filed objection. Objection is only that not maintainable and not maintainable the suit present petition which we have been filed for amendment or additional statement that is has been made by the opposite party, our plaintiff. Objection has been given. Only for the lingering the suit, we wanted to file a written statement and objection. My humble and respectful submission before your lordships is that pass an order, dispose of the suit, dispose of the petition on today itself, and fix a date within 3 months or 2 months to dispose of the suit. I have no objection at all. Then we have been filed. Then my lord, we have been again one application has been filed, document number 12, page 75, my lord.
You come to the impugn order?
My lord?
Come to the impugn order?
Yes, interim order is also that is impugn order. That is impugn order is that is
83 onward.
82, my lord.
83 is the offer.
Yes, my lord, 83. Both sides are represented. Today is fixed for passing order on petition number such filed by the documents defendant under order 6, rule 17, read with section 153 and 151 of CPC, with a prayer to allow the defendant either to file additional written statement or to amend the written statement. Petitioner's case in brief is that the plaintiff has filed the suit without any documents, and as such, defendant had to prepare the written statement based on the averments made in the plaint. That later on, plaintiff has exhibited 10 numbers of documents in his evidence on affidavit. It is submitted that the exhibited documents are not sustainable under the law, being manufactured documents. It is further submitted that as the plaintiff had not annexed the documents along with the plaint, consequently did not supply to the defendant, for which the written statement was prepared and filed by him without getting the opportunity to go through the documents. In view of the above, it is submitted that the written statement requires amended or additional written statement may be allowed to be filed by the defendant. Plaintiff has filed written objection denying any and challenging inter alia the claim or of the petitioner's defendant, and further stated that prior to file a written statement or to amend the written statement.
Mr. Sharma, you directly come to the page number 87. Paragraph
Yes.
number 3.
Further, the discussions of the already made herein above.
No. From the discussion as already made.
Yes, from the discussions as already made herein above, and also from the record, it reveals that the plaintiff was properly presented along with the copies of the reliable documents with list.
Is it a wrong finding?
No, it is a correct finding. But the list of the documents has not been supplied to the defendant.
But it was along with the plaint.
No, it was not along with the plaint. Not with the along with the plaint. That is the question, my lord. When they have been supplied the plaint, that is only the plaint that supplied.
Mr. Sharma, you read the entire this line from the discussion.
Yes.
This. Here, it is observed that the plaint was properly presented along with the copies of reliable document with list. Is it a correct finding?
That is as per the line of trial court. They have filed the suit with the another way. That is the list of the documents. But those list of the documents are not supplied to the defendant.
But you have not taken any stand earlier.
When we have come to know, my lord, at the time of the hearing, at the time of the evidence, and they have been exhibited.
No, you see, paragraph number, page number 85.
Yes, my lord.
Last line of the paragraph, paragraph number 2. Moreover, defendant had knowledge of the pleadings and had the opportunity to seek inspection or to file additional pleading at appropriate stage.
That is my inspection at when I said them. When we came to know that the some documents has been exhibited in the suit without the knowledge of the defendant, then we came before went to the before the honorable court. If the documents we have been not received, how we can file the written statement upon the said documents? How we can take the plea upon the said documents? If the documents are not given to me and it has been annexed, they have been exhibited, and that exhibition has been signed later on, after 3 months, by the line of trial court. After 3 months, it has been, my lord, that has been signed by the line of trial court. That those documents we are not able to know about, that the documents have been filed at the before the line of trial court, before the evidence. More so, when the evidence has been.
Okay. You come to this order 17.
Order?
No, sorry. Order 6, rule 17. Proviso. Not come.
Yes, my lord.
Provided that no application for amendment shall be allowed.
Yes.
After the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before commencement of trial. So here, cross-examination of the plaintiff's witnesses have been completed.
Yes.
Only thereafter you have filed the application for amendment. Where is the due diligence on your part?
My humble and respectful submission that when I have in dark, I don't know about it. Then we come to that, my lord, went to the
No.
honorable court.
There is
The
a
due
finding of
process
the
of law
trial court.
under section 151.
There is already a finding of the trial court.
Trial court on the findings, if your honorable court goes through the documents, that it will be approved.
Okay. Yes, Mr. Borhoya.
My lord.
151 is for the ends of justice. my
No,
lord.
that's all right.
That is fine.
My lord,
That's
there
all
is
right.
a case, my lord, the suit was filed along with the list of documents, which is the procedure laid down for filing of.
The question is whether along with the plaint, the documents were furnished to the
Yes, my lord. The
defendant.
reflects itself, my lord. If they did not receive the document, my lord, page 61, how come they could cross me? Page 61, my lord.
Mm.
May I read, my lord? I
Mm.
am the plaintiff of the case. I do not remember the case number. I have filed the case back, but I do not remember the date of filing. I know the defendant Balika Talukdar, but I do not remember the name of her husband. I know Balika Talukdar since prior to the execution of agreement for sale on 2013. The land under the agreement is covered by dag number so and so village on the part of the covered dag number so and so. It is not a fact. The defendant never received from me money in terms of agreement from where they got my lord. If they did not, for the moment, lordship assume that no document have been received. They just came. How come, my lord, he can say specific date of agreement?
Mm.
It is not a fact that exhibit 1 is the forged or manufactured one. They have suggestions. It is not a fact that I am not entitled.
So,
for-
okay.
Then another thing also, my lord, last line, lordship. It is not a fact exhibit 2 does not bear the relevancy in respect of monetary terms of the agreement. Exhibit 2 also.
No, Mr. Borhoya,
Yes.
this witness was cross-examined on 38/5/2025.
My lord.
And when the amendment petition was filed,
Amendment petition was filed, my lord. After that, my lord. 23-6 at page 64. 23-6.
where the date is mentioned,
Page 70, lordship. 21 day of June 25. Affidavit. Page 70. Well,
Okay.
after cross examination.
okay.
Then lordship will see, we filed our objection. Objection, my lord. Then, my lord, the union order has been passed. Lordship, I like to draw some vital point, my lord. Moreover, the amendment could, page 84, lordship has gone for it.
Mm.
Then, my lord, lordship kindly turn to page 87. From the discussion, lordship has already gone through. Record further reveals that on the day of filing evidence, documents were not signed. Probably because of the reason that the presiding officer was on leave. Thereafter, documents were properly exhibited and by putting signature of the court on 35/25.
Mm.
It has been properly because for exhibiting document, we have already proven original. We need to present, my lord, but trial magistrate was on leave. That's why it was been given on 35. And cross examination they have done 35. Cross examination they have already done, my lord.
Mm.
93 and WS also, my lord, they have never taken plea. That's why, my lord, there is a impin order also reveals, my lord.
Mm.
There is no any procedural lapse or anything. Then, my lord, the impin order is not to be interfered with.
Okay.
That is my humble submission, my lord. Lordship will see the impin order itself reveals everything, my lord.
Mm.
And that is the specific relevant.
Heard Mr. Sharma, learned counsel for the petitioner. Mr. Bormoya, learned counsel for the respondent. Argument concluded, order reserved. We'll pass the order.
Master.
My lord, I am sorry to, my lord, item number 19 and 20, my senior is there opposite party, my lord.
Yes.
I am engaged by the junior, my lord. She suddenly fell, my lord. Pansali Sagor fell in the corridor, my lord. So I want some little accommodation for today, my lord.
Wait.
She left the court already.
Okay.
Just now fell down from in the corridor, my lord.
Okay.
I have taken the consent, my lord.
When can it be listed then?
Within 10 days, my lord.
10 days.
10 days.
Okay. Okay.
At 19 and 20.
Okay. Yes.
So the other side has not been appearing. On the last occasion also it was adjourned because the other side is not appearing and it was given a chance. But we couldn't locate the other side's number.
Heard means as Tode, learned counsel for the petitioner. No, for the appellant. Then appears for the respondent on call. Ms. Tode has pointed out that on earlier occasion also, the respondent remained unrepresented. In view of above, it is provided that Resi shall list the matter after 2 weeks. Kobe fixed that it is of 2010 matter.
On 21st,
20. Thereafter. Thereafter. Thereafter.
28.
Lordship. Lordship, that will be the last.
The event of subsequent non-representation of the respondent, the court will proceed to hear and dispose of the matter without the respondent.
Obliged, Lordship.
17. Respondent. Where for the respondent?
Yes.
The appellant said is, but the advocate, he told me the over phone that he will pay for time
Today.
today.
Okay.
But he is not present. It will be adjourned.
Okay. None appears for the appellant on call. How about Mr. S.C. Sharma, learned senior counsel, assisted by Mr. Vardas, learned counsel for the respondent number 1 to 10, present. Place the matter after 2 weeks. In the event of subsequent non-representation of the appellant, appropriate order shall follow. Here also same thing.
But the, yeah, this is the.
None appears for the appellant on call. However, Mr. S.C. Sharma, learned senior counsel, assisted by Mr. Z. Vardas, learned counsel for the respondent number. You are for all the respondents?
Yes.
For all the respondents present. Place the matter after a week. In the event of subsequent non-representation of the appellant, appropriate order shall follow.
Pattern numbers 21 and 22.
And pass about it for the time being, my lord. Because my senior is on legs, my lord. In court number 7.
Who is your senior?
Nilanjan Deka. Nilanjan Deka. And Deka.
Pattern 23.
Please do this. My senior is coming.
Who is your senior?
Somewhere. S. Ali.
SLA. But the appellant side, on the petitioner side is absent.
Yes.
You're not sure, my senior is on his legs.
Who is your senior?
S. Chakraborty.
S?
Chakraborty.
Okay.
Pattern 25.
Not 21. Physiology, I'm hearing for the respondent. Your Honor, my senior is currently coming right now.
Pardon?
He's the learned counsel is on the way. He's coming right now. In takes some time.
Counsel for the petitioner.
Respondent, Your Honor.
But petitioner is absent. Who is for the petitioner? Okay, after some time.
Timing 21, 22.
Lord, Mr. Ndeka is on legs. That court number 7.
Wait for some time. Let him come.
Maybe some other day, my lord.
Maybe some other.
Okay. As agreed by learned advocates of both the parties, recessal is the matter on coverage.
Timing 23.
Here, my lord, I'll pray for time.
23.
23.
Let it be on that the same date, my lord, on 4th of June.
Okay. As agreed by learned advocates of both the parties, recessal is the matter on 20. 20.
9 June.
9 June.
9 June.
I am ready to hear the matter. But if you are not ready, what to do?
We are also ready. Actually waiting for this.
My lord, the earlier matter that I prepared because that will take a very long time, my lord. The one by where Mr. Deka appeared. I thought, my lord, that will continue the whole
Okay,
day.
okay.
That's
All
the reason, my lord.
All right.
Honestly submitted.
9 June. Timing 25.
None appears for the petitioner on call. However, Mr. Your name?
My name is Benjamin Sisip.
Learned counsel for the respondent present. Lays the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate orders shall follow.
Good. 25.
Sorry for late.
I am appearing in the instruction of advocate and clearly.
Pardon?
I am appearing on behalf of the respondent under the instructions of the engaged advocate and clearly. I could not file my Okalatnama lawsuit today.
Already recorded his presence,
Yeah,
but
yeah,
the
you-
counsel
you
for the
noted me,
petitioner,
Lord.
counsel for the petitioner is absent,
It's short given.
already given.